Hit the little bar at the bottom. All right, here we go. So we are now at the tail end of our discussion on the Supreme Court and the judicial branch as far as a branch of government and the structure. So we've gone over the structure of federal court. Now we're going to go over the Supreme Court itself. So this is a very special court. It's the only one mentioned by name in the Constitution. It's in Article 3. If you actually look through the Constitution, you'll notice Article 3 is one of the shortest ones. It's actually a full branch of government, a co-equal branch with checks and balances. It's equal in many ways to the legislative branch and executive branches. But it's only about 2 paragraphs. It's a very short branch. It's a very, very short article. So there's not much written down. So the idea of the powers of the court, early on in our country's history, we didn't really know what kind of powers it's going to have. It wasn't until a case called Marbury versus Madison, which we'll learn about later on, that we really get into what the court's power became. So just understand that when you're looking at the Constitution in class, that's why that structure looks kind of strange. Like it goes from a gigantic Article 1 in the legislative branch to a medium-sized article in Article 2 for the executive, and this itty-bitty article for Article 3, yet so much power is vested into this court. So it's important to understand the historical context, which we'll go over a little bit later. All right, so let's talk about jurisdiction and organization. So we talked about the jurisdiction of federal courts in general in the last presentation. It's important to know when the Supreme Court is the first court you go to, and there's only 2 instances that ever happens. The first one is a case involving a foreign diplomat. So, like it's an ambassador, like one of our ambassadors or an ambassador from the country. If they have an issue that involves a lawsuit, crime, yada, 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 whatever, they immediately go straight to the Supreme. There's no appellate process. It's just you go straight to the Supreme Court. They're the first court. They hear all the facts. They hear all the issues, and they decide what they're going to do. And the same thing if there's a conflict between a state. So we don't sit there and lollygag around in the lower courts for those big issues because you're talking about a state. It's one of the 50. It's important. We just skip it because we know it's going to end. And part of the reason for this is we know if a state's involved being sued, if it's a conflict between 2 states, we know it's going to go straight there anyway. There's no way it's not going to make it to the Supreme Court. There's too big. The questions are too big, too large in scale, too much population's affected. It's going to go straight to the top. All other cases come to that court on appeal. So it starts at that first district court level down at the bottom. Then it goes to the Court of Appeals or the first appellate court. And then finally it goes to the Supreme Court. And here's the kicker. The district court, you have the right to go to district court. If you pay the filing fee or if you're accused of a crime, you automatically get there. The first Court of Appeals, you have what's called an appeal as of right. As in you have the right to appeal the case no matter what. If it's a civil case, you got to pay up because guess what? That costs money. You got to, if you're going to sue somebody in federal court on the civil level, like for a contract or for a tort or for some other dispute at the civil side of things in the federal court, it's going to cost you a good chunk of change there. So but it still is an appeal as of right. As long as you pay the fee and move on forward, you're good to go. If you're criminally accused and you appeal, you get the appeal as of right, and they assume you can't pay. It's just incorporated into the cost of court costs. But the issue here is the Supreme Court, they choose whether or not to hear your case. Is your case good enough? And more often than not, it's not good enough. The Supreme Court does not pick most cases that come and are appealed to them. So you could have hundreds, sometimes thousands of cases that are appealed from the appellate court, the Court of Appeals, the circuit courts, however you want to say it, appealed up to the Supreme Court, and they'll only take 100, maybe. In cases where the court refuses to hear the decision of the lower courts, that lower court choice stays law. So if the district court, they come to the decision of guilty in a criminal case, and they appeal the appellate court, and the appellate court says, you know what, we're reversing that decision, yada, yada, yada. And then they appeal again to try to say that the appellate court was wrong, and the Supreme Court says we're not hearing that case, that appellate court decision of reversal, that wins. That's the end of the story. The court consists of 1 Chief Justice and 8 Associate Justices currently. Now, as the time we're making this video, it's March 4th, 2017. Justice Scalia passed away last year. There's been an open spot. So just because there's an open spot doesn't mean there's not still 8 associate spots. It just means that there's 7 Associate Justices and 1 vacancy. So you got 1 Chief Justice, then you have you have 8 Appellate Court Justices with you have 7 court justices with 1 vacancy for an appellate court justice. And right now, Neil Gorsuch is up after having been nominated by Trump at this point. And just for the just for the sake of knowing it, the proper title, and I should have capitalized it here, sorry, so my apologies to John Roberts, who is the current Supreme Court Justice. I didn't capitalize your title. It is not Chief Justice of the Supreme Court. You are Chief Justice of the United States, period. It's a very high office. All right, powers of the court. The main job, they are an appellate court. They are just like the Court of Appeals, except they're the next step up. They're just superior, so their rule stands. They basically interpret what the Constitution means and what laws mean. Even sometimes state laws, they interpret the meaning of state laws on occasion. They basically look at law and say what it means, whether it's constitutional law or statutory law or even common law that's passed down through generations of decision making in different court cases and opinions. They also establish whether or not the actions of governments are constitutional. That's when we get to checks and balances. That's the main check that the judicial branch has on the executive and legislative branches. They can declare the actions they take unconstitutional and basically take away their authority to continue those acts. We call this ability judicial review, the ability to review the actions of other branches of government and law. That is judicial review of law, or judge review of prior law. The Constitution does not give the Supreme Court judicial review. If you look in the Constitution, if you press Control F on a PDF copy of the Constitution and type in judicial review, you will get nothing. There's nothing in the Constitution that grants that power. That power comes from a very special case called Marbury v. Madison. I'll give you a quick summary of it a little later on, but for right now, just know it's probably the single most important case in all of U.S. history. Now, in his opinion, Chief Justice Marshall, this is a very, very brief summary of what is in Marbury v. Madison. The decision is like 100 pages long. It's a lot of writing. Basically, he established John Marshall was Chief Justice at the time, and just to give you some perspective on how powerful a Chief Justice can be, remember, these guys are appointed for life. John Marshall was appointed by George Washington. Here's the presidents that John Marshall survived and stayed the Chief Justice for this long. This is how long we're talking. 2 terms of George Washington, so 8 years. 1 term of John Adams, so you have another 4 years on top, so that's 12 years. 2 terms of Thomas Jefferson, we just hit 20 years. 2 terms of James Madison, 28 years. 2 terms of James Monroe, that's another 8 years, so we're now at 36 years. He then survives into John Quincy Adams' first term, so we're at 36 plus another 4. We're at 40 years. Then we get into Andrew Jackson, and he dies during Andrew Jackson's administration. He's in there for a long time. He has influence, direct influence. Not he's influence to this day because Marbury v. Madison is still good law. He had direct influence on the shape of this country for nearly 40 years. That's a huge level of power for a Chief Justice for anyone to have in this country. That's borderline aristocracy, nobility kind of stuff from like the royalty days in England. That's a huge amount of power to have. All right, but let's go back to Marbury v. Madison. All right, so the Constitution is the supreme law of the land. That's the first conclusion that comes from John Marshall in Marbury v. Madison. So that's first of all. We also call it the Supremacy Clause. So basically, the Constitution is supreme, as in it's above all other laws, including state laws. If a law is in conflict with the Constitution wins. So if there's a law that says you have to do X at the state level, and then the Constitution says you can't do X, the Constitution wins. Period. No questions asked. It's done. And finally, the final conclusion of Marbury v. Madison was the judicial branch has a duty to uphold the Constitution. So basically, they look at the Constitution and they look at the action of government and people sometimes, and they basically say, did something bad happen? Was there a conflict with the Constitution? And they're the ones that do it because they are the judges. They interpret, they view law, they look at precedent. Therefore, courts must be able to determine what laws are in conflict with the Constitution and nullify that law. So this idea of nullifying a law through judicial review came out of Marbury v. Madison. They basically took that supremacy clause that is in the Constitution and extrapolated that out to basically say, you know what, if there is a supremacy clause and we have to decide when the Constitution is in conflict with other laws, that means that judges and the judicial branch have to make that determination. So it's our job as justices to make sure that the Constitution is not messed with. The only way to do that is decide what laws mean. If you decide what laws mean, you're conducting judicial review of those laws, and that's how they got to that power. And if you really want to look, there's a quick link to it right there. If you want to look at Colbert Nation, there's a very funny video about this. All right, more powers of the court. Judicial review serves as a major check on the actions of the executive and legislative branch, as I mentioned earlier. It's pretty much the only check on their power. There's another small power that they have in any impeachment hearing for, like, the president. The Chief Justice acts as the judge in that hearing. So that's another check, but it's a very, very small one that's not used very often because impeachments are so profoundly rare. Congress writes laws in general language. So they tend to write laws the way people talk, not the way lawyers talk. Lawyers talk very differently. Legalese is a very different language, and if you were to look at some of these legal opinions, by the time you got through them, you'd be like, I don't know what I just read. I saw a lot of words that were really big, a lot of citations that made no sense, and a lot of parentheses that were goofy. What's going on with this? Legal opinions versus legislation are very different. Legislation, usually, especially early on in U.S. history, was written to be plain. It was meant to be understood. As a result, when you try to make things really simple, you often make things very vague. So that becomes a major issue with judges, because once something becomes vague in the law, how do you enforce it? How do you fairly enforce it? If we made a rule today that says no more eating fried food in the cafeteria, well, what if it's pan-fried? Does that count? What if it's fried at one point, then just reheated on a tray? Does that count as fried food? It's vague. And so who determines what that means? Well, in our case, it'd probably be the school board, which is a semi-legislative, semi-judicial, semi-executive office. But the idea is that rules tend to be made to be understood quickly. But the problem is, when you make them that simple, they don't tend to be easily enforced, or at least it's open to interpretation, which makes it a big problem for courts because they end up being the ones that have to interpret it in some manner. The Supreme Court interprets the meaning of laws. This helps the police and other courts apply them. So sometimes you get down to things like, well, what is it? Does the law say and, or does it say or? If there's a list, in laws all the time, they'll put these long lists in place, and they'll say, comma, blank, comma, blank, comma, blank. Well, what comes in front of those commas? In English, we silently include them. We just like, okay, it's a list, blah, blah. But what if we don't know? What if they don't put and in there? Does it mean and in this list, or does it mean or? Is it conjunctive, or is it disjunctive? That's an issue. The courts have to look at it and say, well, is it fair to make this person serve a 5-year sentence, and we don't know whether the law meant or and. And it can come down to decisions like that. It's not terribly common, but the words have meaning. And for some people, that meaning might be, well, I'm getting the death penalty. So the courts take this kind of stuff very seriously. And again, legislation is written in very broad terms, very general language very often. So you have an issue here. And the courts have to balance that out, and they got to interpret. Usually the interpretation, especially in criminal matters, is always taken in favor of the defendant. It's called the rule of lenity, if in case you want to know and look it up. The rule of lenity basically says if the law is vague, you interpret it in the way that most benefits the defendant, because the idea is you want to protect that defendant's rights because they're superior to everything. If there's a vague law out there that says it's illegal to own a fishing boat inside the state of Utah, well, what if you just what if you drove a fishing boat on a trailer down a highway in the state of Utah? Did you just commit the crime? Well, there's something vague. The court would say we're throwing that law out because it's vague and that defendant goes free. Because the idea is you don't want to infringe on the rights of other people because a law was written in a way that was open to two modes of interpretation. All right, the court depends on the executive branch and state and local officials to enforce the decision. There's a very famous saying, and it's actually false. There's some evidence that never really happened, but John Marshall was Chief Justice during the first Andrew Jackson administration. At one point, he made a major court decision that Andrew Jackson did not like. He was very much against it. Andrew Jackson is reported to have said, well, the Chief Justice has his decision. Now let's see him enforce it. Because guess what? Judges don't have armies. The Supreme Court does not have the military or the power to enforce law. That's the executive branches. So that's a weird check that's unseen. in the Constitution. The executive can check the power of the judicial branch by simply not enforcing their choices, not enforcing their legal decisions. So that's a big issue. So the Supreme Court, it's this balance. Well, if we decide this, we got to hope the executive branch will enforce the decision we made. Otherwise, this whole system of checks and balances just will collapse on itself. Congress can get around the court by ruling or passing a new law. So let's say law X is declared unconstitutional, and Congress is like, well, poo on you, Supreme Court. We'll just pass a new law that's an itty-bitty bit different. They'll pass law X.1, and then now that's a new law. They now have to go back and rule on that law again. It has to go through the whole process. The other possibility, if you have a law that's unconstitutional, is to literally just change the Constitution. Make it so the Constitution is different now. An amendment to the Constitution becomes part of the Constitution. It is a change. It's a differentiation. So the First Amendment and the 14th Amendment are equally parts of the Constitution. The 22nd Amendment is part of the Constitution. So the one big issue that happened during Vietnam, the voting age was 21. The draft age was 18. And there was some evidence out there and some belief that there would be like a lawsuit basically saying that you can't draft somebody and then not let them vote. That'd be unconstitutional. And that could have happened. But before they got a chance to, they just amended the Constitution so that you could vote at age 18, and now there was no more argument. That was one way they got around a potential case that could have like basically interrupted the ability of the Congress to issue a draft. A law must be challenged in a lower court and then come to the Supreme Court on appeal before it can decide the law is unconstitutional. The Supreme Court does not issue what is known as an advisory opinion, and they tried to do that early on in the court's history, and the court basically said no. Essentially, one of the early presidents came up with a law, and they said, hey, well, I really like this idea, and the Congress likes it too, but we don't want it to be unconstitutional, so we're going to just send the law to the Supreme Court and say, hey, review this and tell us if it's constitutional before we enact it. And the court, and this is under John Marshall, was like, no, we are not at your beck and call. We're not your proofreaders. You are going to have to put this law in action. If a case comes up where it gets appealed to us, we will then decide on the merits. But we're not going to give preemptive approval to a law before we know the full effect of it. And that makes sense. You don't want them to be like, okay, well, we reviewed it and nothing we think is bad about it. Go for it, guys. And then all of a sudden, terrible stuff happens, and then they can rely on that advisory opinion to say, hey, Supreme Court, you already said this is cool. You can't say it's not cool now. And off they go to the races. So courts do not issue advisory opinions to legislators, or members of the executive branch, period. They just don't do it. All right, this is how cases reach the court. All right, the Supreme Court conducts business each year from October until June or sometimes July, depending on how the cases work and how the release goes. So they are not on they're on a longer schedule, but they're not on a full-time 50 weeks out of the year kind of schedule. Each month, the justices spend 2 weeks in court listening to oral arguments, so people coming up talking about the cases, and 2 weeks in recess, and that's when they're writing the opinions. That's when they got all their clerks together and other lawyers basically doing all the research to figure out what the final solution should be for each individual case they hear. The court receives most of its cases on appeal, but sometimes lower courts ask for rulings because it's not sure how to apply new law, and this is how that works. You go to the district court, and then they say, whoa, something new just happened. We don't know what to do with this. Think like social media or some new technology coming out that just wipes away everyone's preconceived notions about how to solve this kind of case. And they say, we don't have the tools to solve this. There's no case law on this. If we give a decision, it's going to get appealed because there's no law on this. And they'll basically go to the first appellate court, and usually what happens is the appellate court look and go, holy cow, you're right. We can't decide this either. There's no case law on this. How are we ever going to get to a ruling? And then they'll appeal to the Supreme Court and say, hey, can you just look at this case now? That way we can just get this over with because there's no case law on this. We can't figure out a good ruling. There's nothing even close to what this is. Imagine like the first time airplanes came into existence. Like, how do you decide laws about navigable airspace when no one was flying before? Send it straight to the Supreme Court, let them figure it out because there's no way we can handle this issue. That'd be the kind of situation. Or if because somebody suddenly came up with some new technology, just like airplanes in the early 20th century, there's this rare process where they can just skip all the appeals, go straight to the Supreme Court because it's just a new issue that no court has the ability or the tools to deal with because there is no precedent at all. Now here's the cool numbers. and by cool I mean it's kind of depressing in a way because there's very little chance your case is going to get heard. The court receives more than 7,000 applications each year. It agrees to hear fewer than 200. Now, to be fair, that 7,000 number is also people in prisons handwriting appeals over and over and over again. There was actually a guy, I want to say, was somewhere in the Midwest who was in prison and basically said, "I'm so mad I'm in prison. And I know it costs like a certain amount of money every time he writes an appeal, so he'd just write an appeal every day because he knew it would cost money. Because he's like, I'm going to bankrupt this system one day at a time." And he basically just kept writing appeals, and there's nothing he could do about it. He's in prison for the rest of his life. What are they going to do? They can't stop him from writing appeals because, like, it would be stuff like, I was denied toilet paper for more than 5 minutes in my cell. Bam, he wrote an appeal. Like, do that kind of stuff, just basically to harass the court. And the court can't do anything because he's in prison for life. What can they possibly do to punish him? And his goal was to bankrupt the court system, and obviously it's not working. All right, the rule of 4. So there's 9 justices. If 4 of them say, "Hey, let's hear this case," boom, they hear that case. So that's how they get to this pass number right here. They get to that 200 number right down in the bottom corner here. Yeah, right there. They get to that 200 number by saying, "Hey, if 4 of us want to hear this case, we're going to hear it." They usually select cases that involve important constitutional issues or issues that affect the entire nation. So guess what? Obamacare, boom, right into it. They knew from day one when they filed that bill, when that bill got signed into law, they knew it was going to go to the Supreme Court. The same thing with President Obama's amnesty executive order. They knew that was going to the Supreme Court. Obamacare got approved. Executive amnesty was found unconstitutional. Same president, all that fun stuff, but 2 different conclusions. And the way we get there, the way we get from the Court of Appeals, or really from anywhere, because certainly you can have some rare direct appeals, it's called a writ of certiorari. Now, it's a very hard word to pronounce, so we also sometimes just call it cert, or a writ of cert, just because it's shorter and easier. It's an order directing that a lower court transmit all the records, all the transcripts, all the witness testimony, all that fun stuff, all the exhibits that have been labeled, copies of papers, all that stuff, to the next court to be reviewed, in this case, the Supreme Court. Here's the steps. Each accepted case goes through 5 steps. So 5, really easy to do. There's written arguments. This is where the court will basically just read the basic arguments that they have, and these things can be hundreds of pages long. Not joking. They can be very long. And usually there are some restrictions on length, but sometimes with like Obamacare, this is a huge case. It's going to, in fact, you can't shorten that too much. Otherwise, you're just robbing the ability of the party to actually explain their case in full. So when I say brief, it's in bold. It's not always terribly brief. It's just called a brief of the arguments. Then you have oral arguments. Each side gets 30 minutes to present the case. That's the minimum. Larger cases, 4 hours, 5 hours, as much time as you need, depending on how large the issue is. Obamacare, I think, was 4 hours for each side, which is a very long time. This is all. Oh, sorry. Before I go there, this is also where justices ask questions. So the judges don't. The Supreme Court justices don't just sit up there in their robes and just stare and listen. They get to ask questions. They get to interrupt. So if you've ever given a speech, and these things really do act like these oral arguments are much like speeches. They're up there talking. They have a preset argument they're making. And a judge can be like, "Excuse me, I have a question," and they just throw off the whole flow of it. It'd be like interrupting a singer in the middle of their song. That's their job. They ask questions. They'll be critical. They will say, "What about this law, that law?" They'll bring up arguments that are rhetorical. And sometimes the lawyer who's making the oral argument doesn't have an answer. Like they just throw him for a loop, and that happens fairly often because you don't know what the justices are going to ask. It's not like you send in the brief and then the justices come back with their counter brief with questions. You're flying blind as a person doing oral arguments in front of any appellate court. After the oral arguments, this is the evidence, quote unquote. It's not really evidence. It's just arguing points of law from both sides is done. The justices meet privately and discuss the case. Majority vote will decide that case. All right, the opinion writing. The majority opinion is the official opinion of the court. This is what acts as precedent for later decisions. This is the binding decision. It'll explain the full reasons for all the decisions, just like any opinion of any appellate court will give. Sometimes you will have 2 justices who agree. and they'll say, hey, I think the case should be reversed. Hey, so do I. But they'll have completely different reasons why they agree. That completely different reason is called the concurring opinion. Basically, you agree with the result, but you have different reasons for getting to that result. So some people, like if you were to make it something silly like, what's the best flavor of ice cream? And the majority says vanilla. And they say it's vanilla because, oh, it's the cheapest, everyone else likes it too, it's awesome. And then someone concurs, said, you know what, I agree vanilla ice cream is awesome too. But I like vanilla ice cream because it is the most natural ice cream. There's no artificial preservatives in it. And that's a completely different reason from the majority opinion. But it's still in there. It still acts. It's not law because it's a concurring opinion. The majority of justices did not agree to that opinion. It's just added in there to be influential later on as precedent. It's not controlling, so states don't have to follow it. Lower courts don't have to follow it. It's just there for basically record-keeping purposes. So in 100 years, when the issue comes up again and they see that concurring opinion about ice cream, they'll be like, hey, someone already thought about this. That means it's a good idea, and they can make that argument later on. Then you have the dissenting opinion. And usually in the Supreme Court, dissenting opinions are fairly common. They're not controlling law because they're the losing opinion. They don't win. The dissenting opinion exists. There's very famous cases out there that basically will go into dissenting opinions. And it's almost like the most famous example is Plessy versus Ferguson was a case that said segregation is right because African Americans are inferior. That is basically what the court opinion said. The majority opinion makes this racist, terrible decision. But the dissent is almost the opposite. It says this is wrong. Separate and equal is wrong. It can't exist. It'll never work. Well, fast forward decades and decades and decades in the future, and then you have Brown versus Board. The majority opinion in Brown versus Board of Education basically says segregation in schools is immoral and it's impossible. There is no such thing as separate but equal. That's wrong. That dissent, the majority opinion in Brown, almost mirrors perfectly the dissenting opinion in Plessy versus Ferguson. So sometimes these dissenting opinions, even though they lose in that moment at the time the decision's made, they tend to follow in history and sometimes become the majority opinion in a later case when they overturn prior precedent, which is very rare. But that's why it's so important. It's not so judges and justices, when they do dissent, they'll write down why, because in their mind they're thinking of what's called posterity, the future. I want to preserve my opinion because even though I'm dead and gone, they might one day use my opinion to undo a wrong that was done to a group of people or a person. In this case, African Americans involved in the South with Jim Crow and that kind of stuff. So there are definite reasons why dissenting opinions are extraordinarily important, even though they're not the winning opinions, even though they aren't controlling law at the time. All right. Then after that, you have what's called the announcement. The announcement is when the whole opinion is made public. So this is, and with Obamacare, it was actually kind of hilarious. If you watch videos of the Obamacare, and I might show one in class one day, basically reporters are just sitting out there waiting, and like a clerk from the Supreme Court will just come out on the steps with a pile of papers. They're just copies of the opinion. And it was just when the Obamacare decision came down, it was just a madhouse. You just saw these reporters, and they were reporting what they didn't understand or know about. Like, these aren't lawyers who are reporting; they're just reporters. They're journalists who are just out there reporting the news. And because of the way it was written, at first you thought, based on the language that Chief Justice Roberts used in his opinion on Obamacare, it started out like, oh man, Obamacare is getting canned. They're going to overturn it. So, of course, the first thing you see is reporters going, Obamacare is overturned. Obamacare is overturned. It's over. No more Obamacare. Obama's lost. And then they got through and started reading more and more and more. And like, oh, wait, no, Obamacare is justified. It's a tax. It's under the taxing power. Obamacare, it was just it made you question the validity of journalism in general, because they were just blurting out words they were reading on paper thinking it would stick. They wanted to be the first one to get the story, and it was just CNN, Fox News, they were all just totally messing it up. And I'll find a video of it because it is really bad just watching these journalists who aren't lawyers, who are reading this opinion, just completely confused and just flabbergasted by not reporting correctly. So you have like breaking news, Obamacare has been overturned. Oh, breaking news, Obamacare is approved by the court. It found constitutional. It's just it was like a sad moment in journalism, just because these people were just so fixated on being the first one to do it that they never stopped to think, hey, maybe I should just read this whole thing and then report on it like a responsible journalist. It was kind of a sad moment in journalistic history. All right, now let's go over reasons. So we got to know why the courts decide the way they decide. All right, the law is supposed to be the most important influence on the justice's decision. So in particular, the Constitution as the supreme law of the land. Justices consider how the language of the Constitution applies to each case. This is where you get that whole idea of strict interpretation versus loose interpretation. Do we follow the words as they're written very closely? Like, we don't look for expansion of power. We don't think like necessary and proper, the Commerce Clause, all that fun stuff. Or do we go loose and say, hey, this does, like, necessary and proper doesn't mean needed and proper. It basically just means convenient. That's a very loose interpretation. That's actually won the day. And then you have what's called stare decisis, let the decision stand. This is where the court relies heavily on existing legal precedents or the common law. So if the court sees, hey, okay, 50 years ago, a similar situation happened, the court decided X. Typically, the court's going to decide X again because they're going to follow that precedent to create stability, and it's the entire concept of stare decisis and precedent and common law. We want a stable legal system where we know from decade to decade, year to year, and hopefully century to century in this country what the law will look like, be like, feel like, and how it'll work for the people. At the same time, the law has to be flexible to adapt changing times. So, again, think about airplanes. Airplanes began to exist well over 100 years after our Constitution came into exist. The people who wrote the Constitution had no concept of flight of people. That was something that was literally for the birds. But we've had to adjust and change over time what that means to air traffic control. How does that relate to necessary and proper clauses and the Commerce Clause and interstate commerce, all that stuff that's had to change over time. So there's this idea of the Constitution as a living document that changed with the time. There's also people out there in another camp that say the Constitution changes none at all. The way you change the Constitution is by amending it. And that's a very hard-lined approach to it that really has not won the day out so far. Mostly we've kind of looked with that flexible living document kind of view on the Constitution. Changing social conditions may lead to new interpretations of the law. We will get heavily into this when we talk about the Eighth Amendment. The Eighth Amendment outlaws cruel and unusual punishment. Well, what's cruel and unusual in 2017 is not the same as what is cruel and unusual in 1787. Think about this. In Great Britain and in this country, a thief could be hanged. You could be hanged for stealing. A bank robber could be executed. There were a lot more capital offenses early on. Nowadays, if they were to enact a law in North Carolina and say, hey, bank robbers now must, if they rob a bank twice, they are hung at the gallows at dawn the next day. Obviously, that is not allowed. That would be cruel and unusual given today's social conditions. The electric chair. That's a way to kill somebody, but so is lethal injection. So now states have firing squads, lethal injection, gas chambers. Hanging was only recent. I think hanging might have ended in the 1970s. Was the last hanging execution by hanging. Public executions versus private executions. That's changed over time. Going to an execution used to be a thing you took your kids to, not because it was good, but it was because, like, look at me, boy. This is what's going to happen to you if you do something wrong. Pull the lever, drop, snap, and that the kid would see that. I had a business teacher back in high school. So this is the age difference. His grandfather. So this man was about 50. So this man's grandfather witnessed a public execution. Like his parents took him to like one of the last ones, I believe was in North Carolina, and they're like, "This is what will happen. Like if you do something bad like this, this will happen to you." And they pulled the lever, trapdoor falls, and bam, broken neck. And then that's how they do it. And obviously, that is not how they do it anymore. That's considered cruel and unusual. It's considered an embarrassment on top of death. They don't allow it. Justice's view on the law and the role of courts also influence decisions. This is sometimes known as judicial activism. Judicial activism is when a judge, oftentimes, this is what will happen, a judge or a justice will say, you know what, the law says X. X happened. But you know what, the law is not right. This is unfair. This is not what the law was intended to do. And there are certain laws out there, like there's a lot of gun laws especially, where they'll say, all right, if you have a felony on your record, you cannot own a gun. And there are cases out there where someone will say, hey, the felony was when he was 18 years old, in the 1950s, and the man's 75 now. And the felony at the time was because he spent a felony, guys. In case you don't know, any crime typically that has a year or more in sentencing. That's what makes it a felony, is that 1 year in prison, as opposed to less than a year, which makes it a misdemeanor. But when this kid was 17 or 18 years old, he went to prison for 5 years for, let's say, we'll go with causing a nuisance, like doing some minor crime, something that we wouldn't even consider a major crime today. It would be like a misdemeanor today. It would get you like 10 days in jail. Well, back then, he was in jail for 10 years, like destroying public property. If you've ever seen Cool Hand Luke, he destroyed public property. He got a felony sentence for that. He basically was cutting off the tops of parking meters. Nowadays, that might get you to a felony, but if you just broke one piece of public property, unless it hits a certain amount of value, it's not going to be a felony. And cut to 50 years later, cutting off the tops of parking meters or causing damage to public property is not a felony. But he can't own a gun because back when he did commit that crime, he committed a felony. So now he's been caught with a gun for this old felony in his record that's not a felony anymore. Should the judge put this man in prison for another 5 years for breaking that law? And sometimes judges and juries go, no, that's not right. We're not going to do that. And that does happen on occasion, although I will say this, it's extremely rare. And when it does happen, it usually gets a lot of public press because I say citizens, especially citizens who consider themselves to be very conservative, do not like the idea of judicial activism, especially at the federal level. Because remember, judges are not elected. They're appointed by the executive branch. So this idea of suddenly a judge saying, yeah, I'm not following the law, we don't like that, because we didn't even vote for that guy who's making that choice. But again, think of that gun example. Sometimes judges make choices based on the role of law in the courts in their view. They're using their ideas of what is justice to supplement or replace what should be the decision based on precedent. Typically, people don't like this who view things very conservatively. People who view things liberally also don't like this sometimes, but typically if you're a conservative person and you see judicial activism happen, you're not a fan. Their life experience and personal views also influence their decisions. So if you are somebody who was very conservative from day one, so Scalia, Roman Catholic, raised very, very conservatively, a lot of kids in his family, all that stuff, very rigid, by the books kind of deal. Guess what? His view of the Constitution was very rigid and by the books. He was very textual based. Like, he did not want to leave the words of the Constitution behind. He was not a big fan of loose interpretation. He didn't like the way the Commerce Clause and the Necessary and Proper Clause get used to expand federal power. He was very conservative in his views. Then you have someone like Breyer, who's a bit on there much more liberal. He's like, yeah, I like loose interpretation. I think it works. Living document, the thing should change over time. Amendments are meant to change the words. We're meant to interpret based on changing in social status, and that's think of the Eighth Amendment and how we don't hang people for stealing anymore. Cattle rustling doesn't get you hung anymore because that'd be ridiculous in today's day and age. And that's the entire lecture, guys. Make sure you re-listen to it before the test, all that fun stuff. The next lecture will most likely be on checks and balances in short, so it's not going to be a long lecture. It's basically reviewing how each branch checks the power of the other branches in this little round-robin circular relationship. So make sure you're ready for that.